Nigeria's presidency has responded to reports that a Chinese company, that's Zhongshan Fucheng Industrial Investment Company Limited, had made several attempts to take over offshore assets of the federal government, describing the development as an act of subterfuge. Part of the alleged plan was the reported seizure of 3 aircraft in the Nigerian presidential fleet. According to a statement issued and signed by the special advisor to President Tinubu on Information and Strategy, that's Bayo Onanuga. He said, and I quote, "The federal government is not under any contractual obligation with the company," noting that Zhongshan is trying to use every unorthodox means to strip Nigeria's offshore assets in a case that's allegedly between the company and the Ogun State government. Onanuga added that the statement goes on to say that the federal government is fully aware of efforts being made by the Ogun State government to reach an amicable resolution on the matter. We now turn to a legal practitioner, Baba Issa, to share his perspective on the ongoing controversy in the seizure of Nigeria's national assets and the implication on the international space. Good afternoon. Thank you so much for joining us here on Newsday.
Yeah, good afternoon. Thank you for having me.
Great. Now, can you explain the legal basis for seizing Nigerian government assets over a debt allegedly owed by the state governments in terms of how it aligns with the principles of sovereign immunity?
Well, I think that a few persons have heard, written or spoken about this have actually misconceived the trajectory of events that have led to the seizing of the presidential jets by the Chinese company or other offshore assets of the federal government. Now, the argument being put out there by most of this person is that, one, that there are 2 complexions of this argument. The first one is that the contractual relationship is between a subnational and a Chinese company. In other words, it's between Ogun State government and the Chinese company, that the federal government is not a party to the contract. So the federal government, being not a party to the contract, should not suffer the consequences of the breach of that contract or of that agreement. Now, on the face of it, that sounds like the true position. But now let's backtrack a little bit. Now, the Chinese company came into this country in 2016, thereabouts, got that land to develop their business. But they didn't just appear in Nigeria. Their business in Nigeria and the contract they entered with Ogun State government is actually an offshoot or a product of the bilateral investment treaty signed by the Nigerian government and the Chinese government. So they came into the country pursuant to that agreement. So you cannot interpret or deal with the disputes arising from the agreement with this Chinese company and Ogun State government without looking at the parent treaty between Nigeria and China. So this is where Nigeria as a government, as a federation now, is liable to the contractual conflicts in the relationship between Ogun State and the Chinese government. Because the Chinese company came into the country pursuant to a treaty signed by the 2 countries. So you cannot now claim that, we're not a party to that government, to that contract, because Ogun State government is different from the federal government. When the relationship between the Chinese company and Ogun State was bettered pursuant to the treaty signed by China and Nigeria. You see, one of the things this conflict should teach us, have shown me, is that when you take legal arguments to countries where technicalities has not been canonized or elevated above substantial justice, you get judgments like this. You cannot begin to argue split hair to say Ogun is different from Nigeria and different from Ogun when there was a treaty that Ogun State benefited from. Why will Ogun State expropriate the land of this company without compensation? This is what they do most times to private citizens, to Nigerian businesses. And now Sadly, they have done it to a company that refused to rest on its hours and has fought and fought until this embarrassing situation is staring out at the face. So there is no difference between the Ogun State government and the Nigerian government as long as you read and interpret the contractual document between Ogun State and the company alongside the contractual agreement or treaty between Nigeria and China that was signed in 2001.
All right. Professor Patutomi has given his own 2 cents about this, and he has not shied away from the fact that this is what the government does, that he was a victim of the high-handedness of the former governor, Ibukule Amosu, that he suffered that, and people had even committed suicide. Do you think that moving forward, that probably governors in Nigeria will begin to respect contractual agreements? And my second question is this: is it high time we begin to look at the fine lines in terms of contractual agreements being drawn between past administrations and the federal government, so that we do not find ourselves in this? Because in time past, people have raised red flags about several contracts that were signed between China and Nigeria.
Yeah, I think the answer to your 2 questions is a resounding yes. First, you see, as a lawyer, I'm a litigation lawyer. I go to court every day and I see these things, you know. There are a lot of cases in the dockets of our courts where the federal government, the state government will just take land from businesses, take land from individuals without paying compensation. So it's a culture, it has permeated the fabric of our socio-cultural and even socio-economic wall in Nigeria. It happens every day. There are victims everywhere. If you bring them, if you just open, let's say, a phone line or put a post on Facebook, you see a lot of people come up to say, I was a victim or I am a victim. So this is why we are here. You know, you just feel because you're a governor, because you're the president, because you're a minister. Yeah, the Land Use Act says, the governor of the state is a custodian of land for the people. But the constitution is clear. You can take land that belongs to a business, you can take land that belongs to a company for public interest purposes, but you must pay compensation. Why won't you pay compensation? So this culture, if not nipped in the bud, is even still in the bud. I think it has been exacerbated. It's now flourishing. If we don't stop it, we'll get embarrassed like this. You know, it discourages homegrown businesses, it discourages development, it discourages even foreign businesses like this. So yes, to your question, we must stop this culture of impunity, government impunity, this culture of executive rascality, where people just seize people's properties, seize properties of businesses because they can't fight you and you don't pay compensation. And at times they take this property and they say it's for public interest, but they reallocate these properties for their own personal use or for other individual purposes that are not public interest. Secondly, to your second question, yeah, I don't know. I actually didn't follow the whole process of arbitration, but a colleague of mine, both of us were talking about this, that we're wondering the quality of representation Nigeria got at the arbitration level, the quality of solicitorship that the Ogun State government got, and we really have to begin looking at the fine lines. You know, we need to put our best out there when it comes to how we draft agreements, how we look at the fine lines, how we dot the I's and cross the T's. Because we say this as a joke, but most times, you see, these agreements between Nigeria, China, and other countries, they are agreements that are actually mortgaging our future. You can imagine the embarrassment. An agreement that actually opened the door for a presidential fleet, 3 aircraft in a presidential fleet to be seized. It's embarrassing. It's a shame. So we should be conscious of the kinds of agreement we append our signatures to as a government on behalf of the people, so that we should not suffer not just this embarrassment, but economic loss. We should be more careful.
All said. Now, can we look at any potential jurisdictional issues that might be at play in this case? How do Nigerian, Chinese, and international laws intersect, specifically regarding this matter?
Well, the agreement clearly has an arbitration clause, right? And when you have an agreement, and in the dispute resolution clause, there's an arbitration clause. There is also, the parties are at liberty to choose their arbitration venue. To say, okay, in the event of a dispute, the venue for arbitration, even the venue for litigation, can be in China, can be in the UK, or can be in the US. They can also choose the laws or set of laws to govern the agreement. They can say, okay, this agreement is going to be governed by the laws of the Federal Republic of Nigeria and the laws of the Republic of China. So jurisdiction will not be an issue if these clauses exist in the agreement. If the parties have appended their signature to an agreement that says that the venue of the arbitration, the venue of the litigation is going to be in the UK, is going to be in the US, or is going to be anywhere else. Now, this taken in itself and in interplay with international best practice, international laws and conventions, I don't think that the issue of jurisdiction as it concerns venue comes to play here. The company didn't just appear alone. It was these processes were not had ex parte. I believe that the Nigerian government, the Ogun State government, must have also sent in a representative. They must have made these arguments before the arbitration panel, before the enforcement panel, the enforcement courts, and the JODEX must have looked at the laws, the contract, holistically and decide that there are no issues, jurisdictionally speaking, and there are no issues that will stop the enforcement of this arbitrary award.
All right, Baba Isa, please, how do we strengthen our foreign outlook? Because an international lawyer has spoken to me and said that this is not any surprise, and because you look at precedences over the years and you find out that usually our representation out there, the way the world looks at us, it almost seems like we are weak. Because when you put in the issue with Cameroon over the land dispute, look at how South Africa has treated us in time past, that this is not an isolated case whereby Nigeria goes into a dogfight and always loses or probably comes out badly injured most of the time. How do we strengthen our outlook to the to the international community, that things like this show of shame, does not keep reoccurring?
Well, we should begin by we cannot straighten our outlook without straightening our in-look, in quotes. We should begin by doing our homework well, We cannot have a system where at home everything goes. At home, we have strong men but not strong institutions. Our institutions are not working. Our institutions are not reliable without having that reflect on our outlook. So if we have a system where the judiciary is up and doing, cases are decided on the merit without fear and favor, expeditiously, where we don't have a legislature that is more interested in things like enacting bills about new national anthem, enacting bills about, what's the other one, about, curbing the rights of people, saying that you go to prison if you don't sing the national anthem. We have a legislature that is actually up and doing, enacting laws that are, futuristic. Then we have an executive that obey these laws, obey judgment of God. Then there is no way it is not going to reflect in our public outlook, right? it's going to affect in our public outlook. You know, if you put your best foot in the house, you are going to put your best foot outside the house. I think that's my take on that. If the system is merit-based, you want to employ lawyers in ministries, employees, they're all merit-based. You see that it's these same persons that will represent us out there. It's also going to be merit-based. But when we have a shambolic system in here, we are going to have a shambolic representation out there. So, as they say, charity should begin from home. Then charity can shine abroad. I think that's my take on that.
Well said. I certainly appreciate the fact that you're talking about us needing to strengthen our institutions. But in the event that this Chinese firm Seizure is found to be unlawful, hypothetically, what are the legal implications in terms of penalties or consequences that might be faced?
I didn't get that. In the event that the Chinese firm is found unlawful,
the seizure is found to be unlawful, hypothetically. If during the course of time the seizure is found to be unlawful, what are we looking at in terms of legal penalties or consequences?
Well, the judicial process have not ended. I don't think it has ended. Has come to an end. We are talking about the judgment or the arbitral award or the position of the law as it is. Now, if there is a room for appeal, of course, the Nigerian government or the Ogun State government, jointly and severally, can appeal it, can review it, right? And if it is found that this judgment was given in error or the seizure was done unlawfully, then of course there should be penalties for that. There should be cost, and they should be able to set aside the award and set aside the judgment. It's just a normal process. So if it is found to be unlawful, there are legal remedies. Of course, damages, set aside the award, and all of that would take its course. I think as it is done anywhere in the world, that is how it's going to be done in this case. But as it is right now, it has been found several times. I think the first time they got this arbitral award was in 2021. Yes, 2021. So they have gone to several courts in several jurisdictions. They have been to France, they have been to the UK, been to the US. And the Nigerian government have also appeared to argue that they have argued even their sovereign statute, whatever, but the courts have not agreed with them. So hopefully, if we can get a court that will agree with them, agree with us because we are all part of it, then of course, we will learn from it and do better next time.
All right. Let's talk about the former governor, Ibikunle Amosun, and his role in all of this. He seems to have apologized. Of course, he released a statement. But do you think that is enough?
Well, I don't think that is enough. I think it's shameful. It's shameful that we are where we are, and the best we can get is an apology. You see, when our leaders, present or past leaders, are made to account for serious infractions like these that have actually cost us a lot of money, cost us a lot of social, even political capital, not just economic capital, I think there should be some kind of sanctions. A leader should not just say, I'm sorry, and that is it. I don't think that's enough. There should be kind of sanction. I don't know right now, thinking off my head, the kind of sanctions that should be meted to the governor or the former governor. But I think he should do more than that. And I think at this point, the Nigerian government should stop grandstanding. All this grandstanding, we are right. Because from my experience, there is nothing that cannot be settled. Even if you get a judgment against somebody, it can still be settled. At this point, the Nigerian government can still talk to the company, maybe even through the Chinese government, and say, come, let's stop this embarrassment. How are we going to settle this? You can say, okay, let me pay this, let me pay half of it, and this ends it. But when you keep grandstanding, you keep talking tough, you keep calling names, it gets worse. It's like driving into a pit and not even taking time to check where you are going to. So our leaders should do better than this. And And we deserve better than this.
Well said, especially considering your last recommendation that there might be other ways to conclude this. Thank you so much, legal practitioner, lawyer, Baba Issa, for joining us. We appreciate your insight and your time here on Newsday. Thank you.